Teri's been at the bar now for 10 years. Before that, she was admitted in 1997. She has published 2 papers that are available on Green's List website, and I had the pleasure of attending her presentation 2 years ago on pitfalls in your wills and estates practice and how to avoid them. Both an excellent paper and an excellent presentation, so you know what to expect from her presentation this morning. Teri has given up her marathon training to come and be with you this morning, and to me that's not a terrible thing to have to give up, but for Teri it is, because she's at the pointy end of her training. You'll benefit by her paper and the presentation and her selflessness in giving up her marathon training. She also works in areas outside wills and estates and trusts, corporate insolvency and bankruptcy, intellectual property, joint ventures, derivative actions, estoppel, all that sort of outside but related equity experience. Also retail property and leasing. She too is a mediator like Peter and myself, and her paper will deal with Rule 10, which is the professional conduct rule that tries to balance the duty to put the client first and the practitioner's right to payment, fair payment for work done, and the added requirements that have been carefully laid down by Justice Habersberger in a case called Schmulowitz last year, which sets out what is required for informed consent to charges for adopting the onerous duties of an executor and professional charges of a solicitor. Thank you, Teri.
Thanks, John. I'm going to pay for missing my marathon training this morning. My trainer has already warned me that I've got to make it up. So I'm very glad to be here in any event. So welcome to you all and good morning. Before I get into my paper, I've attached, or with my paper, there is a notice to practitioners from the Registrar of Probates, Michael Halpin, which I've included as part of the presentation. And I included it, Peter very kindly brought it to my attention, but I included it because I think it's important that we all understand the existence of Rule 10 and how it operates and what we need to do to comply with it and not fall foul of it. If a client comes into your practice and with a will issue or a will matter, be it drafting or will caveat or litigation in respect of a will, I think that it's fair to say that you should play a very careful word association game. And as soon as you hear the word will, you should very quickly associate it with Rule 10 because the two go hand in hand. And I find it interesting that in 2010, Michael Halpin thought it necessary to bring to the profession's attention the rule, which by that stage had already been operating for 5 years. It had come into operation on 30th of June 2005. And as the Notice to Practitioners states, it has come to the attention of members of the Probate Users Committee of the Supreme Court that a number of practitioners are unaware of the existence of Rule 10 albeit that the current rule came into play on 30th of June 2005. And he then goes on to state that the relevant rule places limitations upon practitioners who prepare wills for clients under which they or their associates receive a benefit, such as an entitlement to charge executors' commission. And despite the existence of the rule, the committee is concerned that some practitioners may not have complied with the rule And that's pretty amazing statement to make, that 5 years on, the Supreme Court is still concerned that the rule is not being complied with. And having said that, and having read the practice note, I haven't been able to find any cases, apart from the most recent decision of Smulovich, Justice Habsburger's decision. No other cases in the will and probate jurisdiction have expressly dealt with Rule 10 and what is required to comply with it. So it's a bit of an unfair criticism for the Registrar of Probates to make, but nevertheless, it is, I guess, something that we all need to be fully aware of and ensure that our practices are put in place to comply with the rule in every respect. And I'll go through with giving some practical examples of how exactly to do that. John mentioned the inherent tension between solicitors acting as executors and the fiduciary duties which we all know solicitors owe to their clients. And that's a tension that is very often difficult to reconcile, but can be done. It is possible. I've referred to Justice Kirby's comments in Maguire and Macaronis in the paper. He refers to the susceptibility of human nature to temptation. And I make the quip there that, contrary to popular belief, lawyers are, after all, human and susceptible to temptation. And I think that in the context of solicitors acting as executors, it's not so much that you're susceptible to temptation, but more that you're susceptible to the pressures of the client, to agree to what they want and to ensure that their wishes are carried out to the fullest extent. So it's a bit of a tension that you need to be careful to resolve. In Maguire's case, the case there, I footnoted very briefly the facts, where the case concerned two solicitors who had entered into a short-term loan agreement with their clients who needed funds to purchase an interest in a farm poultry business. And the solicitors secured a mortgage in their favour on standard terms, and the High Court held there that the solicitors had very clearly breached their fiduciary duties by placing themselves in that conflict, because there was a clear conflict between their duties as solicitors and the interests of the clients. And that happens all the time in this area where you're acting as an executor. You're always going to be in conflict because you're entitled to be remunerated for your professional legal costs in administering the estate. You're entitled to claim commission for your pains and trouble in administering the estate. And you're also a fiduciary to your client. So how do you reconcile that tension? Well, what Rule 10 does is give you some guidance as to how you can reconcile it by ensuring that your interests are still available to you, yet you're still recompensed for your work, for your very hard work and efforts in administering the estate. And, but at the same time, you need to ensure that your client understands the extent of that obligation and what is necessarily involved in that process, because they may not fully appreciate it. So I've extracted the rule on page 3 of the paper, but before that I've included a preamble. Rule 10 is found in the section of the Professional Conduct and Practice Rules of 2005 under the section headed Relations with Clients. And I'll read the first part of the preamble because I think that really does set the tone and succinctly summarises your obligations and what you really need to be aware of. And the first part of the preamble states that practitioners should serve their clients competently and diligently. They should be acutely aware of the fiduciary nature of their relationship with their clients and always deal with their clients fairly, free of the influence of any interest which may conflict with a client's best interest. So that is the tenor of Rule 10. that is what it seeks to do, and what you need to do is also ensure that that basic tenor is complied with. Interestingly, the main case that's cited on this particular topic is the late Master Evans, as he then was, his decision in Re Will of Mary Irene McClune. I'm sure all of you are very familiar with it. But the case there concerned two professional executors. One was an accountant and one was the solicitor. And the accountant actually had taken out his professional costs in it for administering the estate, but there was no charging clause for him to do that, so he was very promptly ordered to pay that back into the estate. He was, however, awarded his costs for acting as an executor, so he was compensated for that part of his efforts. The solicitor was not so lucky. Even though there was a commission clause in that will, Master Evans disallowed commission to the solicitor in that case because he found that not only had the solicitor failed to make disclosure pursuant to Rule 10, but that in any event the professional fees and charges that he had levied on the estate had well and truly compensated him for his pains and troubles, so there was no order for commission made in that case. But what I found interesting about this, and Peter and I discussed this yesterday over my Earl Grey tea and his cappuccino, I think it was. What was interesting about that was that decision was handed down a year after the rule came into effect, and it appears that Master Evans may have not himself fully appreciated the extent of the rule and what was required, because he does state, and I've extracted part of his decision in the second paragraph, he does state that given the real potential for a conflict arising between the interests of the client and the interests of the solicitor on such an occasion, it would be preferable that solicitors decline to act as executors. At the very least, the solicitor's code of conduct should provide very clear guidelines as to the proper course of conduct on such an occasion and require the provision of written advice in relation to the decision to appoint a solicitor as executor. Well, that's what Rule 10 does. It does provide clear guidelines on what you need to do, and it does mandate that you need to give written advice to the client and make full and frank disclosure about what your entitlements are as executor under the will in relation to commission and also in relation to legal costs. So it's a curious decision in that respect, but nevertheless it does highlight your obligations in that regard. So at pages 3 and 4, I've extracted the rule in its entirety. I won't read it out, but the best way to understand the operation of the rule, I think, is just to break it down. And you can break it down into two distinct but related categories. The rule operates in two ways. It operates firstly where a solicitor executor receives a benefit under the will, either in the form of executor's commission and in the form of legal professional costs. And in that situation, where you are receiving such a benefit, you are required to disclose to your client in writing three matters, three facts. First of all, and this can be found in Rule 10.1, you need to advise the client in writing that you or your firm or an associate of your firm are entitled to claim commission, first of all. Associate is defined in the rules, and it includes not only lawyers but non-lawyers, companies or partnerships where the solicitor has a material beneficial interest, for example, trustee companies. It includes other partners of the practice and co-proprietors. It includes employers and employees of the practice, and the solicitor's immediate family and that of a partner's immediate family. So it's quite a far-reaching definition. Secondly, you need to advise the client in writing that the will entitles you, your firm, or an associate of the firm to charge legal costs in relation to the administration of the estate. If you're able to provide an estimate of what those costs would be, then you should let the client know. You might not know at that point. You may not have any idea. You may not know what the full assets of the estate are, and you're still getting instructions on it. But where you are able to give an estimate of your costs, then that would be certainly useful. And finally, and this is where most practitioners may not be aware of this particular obligation, but you are required to advise the client, again in writing, that they are at liberty to appoint an executor other than a solicitor or a firm of solicitors who might make no claim for commission. So you need to give them the option. It's not a given that everyone that acts as an executor will charge commission, and they need to understand that. So there's an option for them. If they can find someone that can do it for free, then they're entitled to be given that alternative. So they're the three facts that you need to advise a client of in writing if you are to receive a benefit under the will in the form of a commission if you're acting as executor, or in the form of legal professional costs. The second limb, if you like, of the rule operates where solicitors receive what's defined as substantial benefits under the will. And a substantial benefit is defined in Rule 10.3 to include any benefit that has a substantial value relative to the financial resources and assets of the person intending to bestow the benefit. That's the definition. Now, granted, it's not exhaustive, but it does require you to use your professional instinct in determining that, for instance, if the client's going to transfer their property to you, that's clearly a substantial benefit, be it inter vivos or by the terms of the will. So you just need to trust that little voice in your head that says, look, this doesn't feel right, something's not quite right here, I better just make sure I'm doing the right thing. And so when you receive if you are likely to receive a substantial benefit, this is in addition to and over and above the benefits that you may receive under the will in respect of legal professional costs and commission. So this is in addition to those. In that instance, if you are in a position where you are receiving such a benefit, you must decline to act. The rule is unambiguously determinative in that respect. You must cease to act, you must decline to act, and then you must offer to refer the client for advice to another solicitor who is not an associate of your firm. So this is very, very difficult, I think, and practically speaking, you'll find yourself in a position where you have a disaffected client, a client that feels offended. You've got to remember that you've probably been acting for this client for 20 years. You've probably been the family solicitor for as long as you can remember. You're the only one that knows the ins and outs of the family relationships and family dynamics. And the client feels that they've reposed quite a bit of trust in you, quite a bit of confidence in you, and they probably feel that they're bestowing on you a privilege for you to act as their executor. And suddenly you turn around and say, I can't, or I must decline to do so. That presents quite a client management challenge for you, and you really do need to handle that with kid gloves if you can. The best way, Peter did raise an example with me yesterday, and I've got permission to talk about it, but he was involved in a case recently where a solicitor executor was very much in the gun for not complying with Rule 10, and this was at a mediation, and it was sought to be resolved, and her argument was, well, the client said to me, don't you want my gift? Don't you want my benefit? You know, I'm trying to do the right thing here. And so she felt compelled, because she felt that she was offending the client, that she felt compelled to take the gift, even though it was clearly something that she should have thought very carefully about doing. And another example I can think of is where the client tells you to insert the clause. This is in fact what happened in Smulovich's case, where the client says, "Look, you've done so much work for me. I trust you. I know this is going to be difficult for you. Just insert a commission clause in there and a charging clause in there, and it's all good. You do what you think is best." And you feel as a diligent solicitor that you're going to comply with your client's instructions, so you do what you feel is best. That doesn't absolve you of your obligation to explain to the client the effect of the clause that you're going to insert, what effect that has on the corpus of the estate, because it may be that the client intends for certain gifts and certain bequests to be made, but they may be reduced by the costs that will be taken out and by the commission that will be taken out. So it's very easy to feel pressured by the client. It's very easy to feel that you're following your instructions, that you're doing nothing wrong. But a word of warning that you need to be aware that even so, you still need to comply with that obligation. You still need to sit them down and say, yes, thank you very much, I will do that. But you do understand that the consequences of this clause is this, and let the client decide. So I will talk about Smulovich's case because, as John mentioned, it's had quite a bit of airplay. It's quite a well-known decision of Justice Habsburger. And Justice Habsburger extracts part of the rule in his judgment. And in the course of his detailed reasoning, His Honour explains how the solicitor executor in that case failed to comply with the rule. And he failed by not giving the client, not obtaining informed consent from the client. And that's the key word, informed consent. In fact, it came out in cross-examination that the solicitor executor admitted that he didn't know the existence of Rule 10. He didn't know it was there, and he didn't know that he had obligations under it. So there you go. The plaintiff beneficiaries opposed a claim by the defendant executors for commission and legal costs, and in their originating motion, I should just say that the case had a colourful history. It did survive a strikeout application before Associate Justice Mukhtar, and it's worth reading Associate Justice Mukhtar's decision because he also makes some pretty critical remarks about the inclusion of that particular commission and charging clause in that case, which were echoed by Justice Habsburger in Smulovich. But the basis for the plaintiff's objection was that Mr. Recht was the deceased solicitor and had been for many years, that the will was prepared by him or by his employees under his supervision, that there was therefore a fiduciary duty owed between him and the deceased at the time of making the will. That's also very important to emphasise. And that the relevant clause under dispute gave the defendant executors significant benefits, which included the right for them to charge their legal costs and for commission for all business or acts done by them in their professional roles in connection with the will. That's pretty broad and pretty far-reaching. All business, all acts done. What does that mean exactly? And moreover, the executors were entitled to claim 3.5% on capital and 5% on income, and that was irrespective of the extent of the work to be performed and irrespective of the pains and troubles. So what they were in effect seeking to do was to basically oust the court's discretion. The clause was worded in such a way where the client perhaps thought, well, there's nothing more to investigate here. That's what the clause says, that's what the clause does, that's the end of it. And Justice Habsburger was in fact quite critical about that sort of drafting. And it followed then, the plaintiffs argued that by reason of the above matters, that the benefits under the will were in breach of Mr Reck's fiduciary duties owed by him to the deceased. The defendant executors relied heavily on the High Court's decision in Maguire. In effect, they sought to rerun the strikeout application before Associate Justice Mukhtar, and they argued that it was necessary for the plaintiffs to establish first that there was a fiduciary duty owed, that there had been breach of that duty, and then the relief that followed. And it was argued that the plaintiffs had failed to discharge their onus in that regard, and so therefore there was no case for the defendants to answer. Secondly, they argued, a further argument was that there was in fact no benefit received by Mr Recht under the will, because the will was only giving him what he was entitled to. It was compensating him for his legal costs administering the estate. It was compensating him for his pains and trouble. What's the problem? That's not a benefit, that's a right. And of course we all know that there is no automatic right to commission. There is no automatic right to legal costs. That is in the discretion of the court if the beneficiaries do not agree, in which case off you go under Section 65 of the Admin and Probate Act, make your application and the court decides. So, and going back to how the clause was drafted in that will, and I apologise, I should have actually extracted the clause, but it would encourage you to read the case and read the clause. But the way it was drafted, as I mentioned earlier, it was so far-reaching that Justice Habsburger found that there was in fact a benefit received, and the benefit was not having the court investigate the legal costs and commission to be charged. That's the benefit, and that's the benefit that the solicitors received in this case. And His Honour, in fact, said further on that point that it mattered not that an executor might be able to obtain an order from the court allowing commission at the same or even higher rate or amount. The benefit to the executor is in not having his remuneration for the work performed by him reviewed by an independent body such as the court. That's how His Honour described that benefit. And His Honour found that Rule 10, as I've mentioned on a number of occasions now demanded informed consent, and he found that in that case there was no informed consent for the following reasons. Firstly, the testator was not told that there was no automatic right to commission for executors, and that he did not have to include a clause in the terms of that clause, there was a choice not to include it. He was not told that in the absence of such a clause that the solicitor executor would need to go to the court under Section 65 to make an application. That wasn't advised to him. He was not told that if the clause in the will was included, that the executors would be entitled to receive 3.5% of capital and 5% of income, irrespective of the amount of work that was done. That wasn't advised. He was not told that if the clause was included, that the beneficiaries would be unable to challenge the level of the executor's commission. That wasn't advised. And he was also not told that the rates included in the clause were not in fact fixed, that they could be reduced or negotiated. And I would use those findings of His Honour as a guide in how you advise your client under Rule 10. I would be advising them of precisely those matters. That should suffice. I think now, Peter Pascoe did mention the prior wills and prior patterns of will drafting. And in Smulovich, it also came to light that the testator there had made previous wills, and the previous wills had not included a charging clause or commission clause. And the final one that he signed did. That's okay, there's nothing wrong with that. If you do find if a new client comes to your office and and wants to draft a new will, you should, as Peter pointed out, ask for the earlier copies and see what the pattern of will making has been. If there hasn't been any charging or commission clause in the previous wills, it doesn't mean you shouldn't include it now. All it means is that you need to ensure that you comply with Rule 10 in order to protect yourself. So in that case, His Honour found that there was no previous such clauses in the previous wills, coupled with the fact that there was no disclosure under Rule 10, raised a very serious concern for His Honour. So I think it's definitely worth making it a point of practice in your daily routine to ask for those previous wills, see what the situation has been in respect of professional costs and charging clause and commission clauses, and if you need to include it and the client agrees, ensure they get the proper advice about it. And I've ended the paper with just putting down some practice points, and it's probably a lot of it's common sense, but it doesn't hurt to reiterate it. First of all, I would consider very carefully an invitation to accept an executorship. It is an onerous responsibility. It does involve a lot of work. You do need to keep separate files and have them costed. And I think if you explain all of that, and if you don't have the wherewithal and the resources to manage that, then the client will understand, particularly if you know them well and they accept your limitations in that regard. So don't be afraid to consider the invitation carefully. And of course, if you're accepting an executorship, advise your client in writing. It needs to be something that you should do as an automatic, not even thinking about it. What I would do, I've said it further down, but I would keep the advice together with the deed packet. Don't put it on the will file. Files go missing, they get destroyed. If you have it with the deed packet, it's all there. There's no risk of it being lost or destroyed. Of course, be cognizant of your obligation to decline to act if you're receiving a substantial benefit, and explain to the client why that is so. And just because the client has instructed you to include a charging and commission clause, it doesn't mean that they're giving you informed consent, and that's where your advice becomes very important and very critical. I would encourage your client to negotiate a commission clause and a charging clause. I think that if you include them in that process, they feel that you're working together as a team, and that you have their best interests at heart, and that you're also concerned about ensuring that their wishes are fully met, but that you're not missing out on being compensated for all of those pains and troubles in doing so. So include them in the process. Sit them down and talk about commission rates. Talk about the likely rates that courts will award in the event that there's no agreement by the beneficiaries. 3%, even though the Section 65 does allow for commission to be charged at a rate of 5%, it's very rare to get 5%. I mean, you're talking about million dollar estates, very complicated estates. I guess really what you're looking at is, 3%, 3.5% is not unusual. But talk about that with your client. That's the point that needs to be made there. And of course, never lose sight of your fiduciary duties and obligations. These are paramount to any claims that you may have on the estate. That concludes the paper, but before I step down, I did also want to mention one other matter. The Victorian Law Reform Commission has very recently has been asked to review the succession law in this state and wills and probate jurisdiction. And I've got a copy of the succession law terms of reference, which I'll ask Michael Green to put on the website for you. But some of the topics for further review are family provision, intestacy, administration of estates and the operation of the jurisdiction generally, but more importantly for our purposes today, one of the terms of references involves legal practitioner executors, and the Victorian Law Reform Commission is being asked to review whether there should be special rules for legal practitioners who act as executors and also carry out legal work on behalf of the estate, including rules for the charging of costs and commission. So if you thought after today that Rule 10 was onerous and giving you more work, think again, because I can say with some confidence that after this review is over, there will no doubt be yet more regulation placed on practitioners who act as executors to protect rightly protect the clients. Unfortunately, the terms of reference have only just been released literally a couple of days ago, so I haven't been able to give you examples of what some of the papers are considering. Perhaps it's a topic for another session, but it's definitely a watch this space topic, and we'll see what that review throws up for you all. Hopefully it's not too much of a challenge for you. That concludes my paper. Thank you very much for your attention.
Thank you very much, Teri. Are there any questions? Please.
Ro Krivenek from Judge and Papaleo. I'm just wondering whether in ticking off the knowledge and approval reference, that in any way dilutes the requirement to have to receive explicit instructions from the testator.
Peter, would you?
Is it like a substitute for explicit instructions that the person understands or appears to understand what is read to them of a will that has been drafted without their being able to articulate all the conditions of that will?
I'm just wondering if I understand the question correctly. I don't think there's any dilution of any pre-existing requirements. Knowledge and approval, as I said, is really the theoretical basis upon which you're later often doing an affidavit of due execution. So the two things merge together in that respect.
Yes.
But it's just that it has a particular role to play in these grounds of objections to the essential validity of a will, and it is something that has an element of subtlety about it, and really I think from a practising solicitor's point of view it's best dealt with by good prudent practice, and I do apologise for my phone going off. If I haven't answered your question, perhaps we could have a quick discussion about it later.
Thank you very much.
Okay.
Yes.
Yes, I do apologise.
Are there any other questions?
Could I just finalise it, because of time constraints on this basis, just taking up from where Teri left off. It seems to me that it's very important that you realise that the doctrine of informed consent is a superadded requirement over and above Rule 10. Just make sure that you're very much aware of that. The two things not only sort of go together, but just strictly complying with Rule 10 may not result in your client giving fully informed consent. So if you go back to those particular aspects of Justice Habsburger's judgment where he says, based on the evidence in that case, the client would not have known, and then he listed 5 or 6 points. That's really a template for how you go about getting your fully informed consent that's more than just mere compliance with Rule 10. Yes, thank you.